What's up, everybody? So yesterday on February the 7th, 2025, Kathleen Zellner, on behalf of Stephen Avery, filed a petition for review with the Supreme Court of the state of Wisconsin. It's 31 pages long. Let's jump right into it here. Whether the Court of Appeals improperly imposed a burden on Mr. Stephen Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State versus Edmonds. The trial court held no. The Court of Appeals held the trial court correctly deemed the newly discovered evidence would only be material if it was admissible under Denny. Number 2, whether the Court of Appeals erred when it did not correctly apply State versus Denny. The trial court held no. The Court of Appeals held the trial court correctly applied Denny to Stephen Avery's potential third-party suspect evidence. Number 3, whether the Court of Appeals improperly affirmed the trial court's decision to deny Stephen Avery an evidentiary hearing. The trial court held no. The Court of Appeals agreed. Criteria for granting review. This case presents special and important reasons justifying Supreme Court review. The Court of Appeals conceded that the Thomas Sawinski affidavit establishes a possible connection between the third party and the crime. The court reached this conclusion by improperly weighing the evidence and imposing an improper burden of proof on Stephen Avery to meet the standard for an evidentiary hearing. This misapplication of law and misrepresentation of the facts has resulted in a constitutional violation of Stephen Avery's due process to present a complete defense at his trial. Issue 1, misapplication of State versus Edmonds and Brady versus Maryland. The first issue concerns whether the Court of Appeals misapplied the standard for evaluating newly discovered evidence on post-conviction, which is governed by the State versus Edmonds. By restricting Stephen Avery's new evidence to establishment of potential third-party suspect evidence governed by State versus Denny in order to satisfy the materiality prongs of Edmonds and Brady, even though Mr. Stephen Avery offered numerous reasons why newly discovered evidence is independently material without regarding to the Denny third-party suspect standard. The second issue concerns whether the Court of Appeals misapplied the standard for potential third-party suspect evidence set forth by State versus Denny. By creating impossible standards for satisfying the motive, opportunity, and direct connection prongs of Denny in a post-conviction pleading, contrary to Wisconsin law, the court should grant review because the Court of Appeals' decision is in conflict with the court's decision in State versus Denny. Issue 3, misapplication of State versus Balliette. The issue concerns whether the Court of Appeals misapplied State versus that same last name in Denny, Mr. Stephen Avery, an evidentiary hearing, and in doing so deprived Stephen Avery the ability to raise a complete defense in violation of his constitutional rights. The case presents unique and constitutional issues based on the Court of Appeals' misapplication of the law and a misrepresentation of the facts to Stephen Avery's case and his newly discovered evidence. Statement of the case. On March 18, 2007, Stephen Avery was convicted of first-degree intentional homicide and felony in possession of a firearm. He was found not guilty of mutilation of a corpse. In 2009, he filed a motion requesting a new trial. An evidentiary hearing on Stephen Avery's post-conviction motion was held. On January 25, 2010, his motion was denied and he appealed. The Court of Appeals affirmed. In 2013, Stephen Avery filed a motion requesting a new trial. It was denied. On June 7th, 2017, Stephen Avery filed a second motion The petition was dismissed without an evidentiary hearing. Stephen Avery filed a motion to vacate on October 23, 2017. He filed a motion for reconsideration. The circuit court denied his motions to vacate and for reconsideration. On October 11, 2019, Stephen Avery filed an appeal. Stephen Avery filed motions to stay and remand concerning 2 additional claims. Stephen Avery raised his claims in his motions to the circuit court as a supplement post-conviction motion. The circuit court denied his motions to supplement. On April 12, 2021, a new witness revealed exculpatory information impeaching Bobby Dassey by establishing that he put the victim's car on Stephen Avery's property. Stephen Avery filed a motion to the Court of Appeals to stay his appeal and remand to allow Stephen Avery to add a claim based on the new witness. On July 28, 2021, the Court of Appeals issued a per circum opinion upholding the circuit court's summary denial of Stephen Avery's claims raised in his petition and 2 supplemental motions, holding that Stephen Avery's motions were insufficient on their face to entitle him to a hearing, but reserving his ability to refile his supplement motion number 6. On August 16, 2022, Stephen Avery filed his 3rd motion for post-conviction relief. Stephen Avery filed an amended motion on December 6, 2022. Motion set forth newly discovered evidence that a third party, Bobby Dassey, was seen in possession of the victim's, Teresa Halbach's, vehicle after her disappearance. Mr. Thomas Sawinski contacted the New York Innocent Project about this matter in 2016. Although Thomas Sawinski originally believed it was Stephen Avery's trial defense attorneys that he contacted in 2016. After finding an email verification, he realized it was rather the New York Innocent Project he contacted, and thus amended his original affidavit, which was submitted in Stephen Avery's motion to stay his appeal to the appellate court, and Thomas Sawinski's amended affidavit was filed to the circuit court reflecting this mistake. Affidavits from 2 other new witnesses in Stephen Avery's case, Mr. Kevin Romlow and Thomas Burish, corroborated Thomas Sawinski's observations. In Stephen Avery's motion, Mr. Avery also raised Brady claims relating to the information from the new witnesses. Mr. Avery attached affidavits and documents showing that after Thomas Sawinski contacted Stephen Avery's current post-conviction counsel, providing the newly discovered evidence, Stephen Avery's current post-conviction counsel, through its investigation, submitted its second public records request pursuant to the Freedom of Information Act to the Manitowoc Sheriff's Office for audio recordings of incoming and outgoing calls and or radio dispatches between November 3rd, 2005 and November 9th, 2005 related to the case. The FOIA produced audio recordings did not contain the Thomas Sawinski call, nor did they contain any dates or times of the calls produced. In May of 2022, Stephen Avery's current post-conviction counsel received the previously suppressed Thomas Sawinski call to the Manitowoc Sheriff's Office, which contained a partial recording of the Thomas Sawinski suppressed call to the Manitowoc Sheriff's Office on November 6. For the first time, current post-conviction counsel received the exact dates and times of the Manitowoc County Sheriff's Office incoming calls. As part of its investigation, Stephen Avery's investigator then reviewed Thomas Sawinski's ex-girlfriend, who he was dating at the time of the November 5, 2005 incident. Thomas Sawinski's ex-girlfriend, Devin Novak, corroborated Thomas Sawinski's account of what he had witnessed and what he had relayed to law enforcement. Furthermore, Devin Devin Novak recognized and identified Thomas Lewinsky's voice on the recording played to her by the investigator of a phone call made to the Manitowoc Sheriff's Office on November the 6th, 2005 at 10:28 p.m. Stephen Avery's investigator interviewed Thomas Lewinsky again and played the same audio recording of the phone call that was made to the Manitowoc Sheriff's Office on November the 6th, 2005 at 10:28 p.m. Thomas Lewinsky identified his voice in the audio recording of the phone call from November the 6th, 2005. The recording of Thomas Lewinsky's call was never disclosed by the state to Stephen Avery's trial defense counsel prior or during the trial. Pre-trial, trial defense counsel made two specific requests for all exculpatory evidence and or information within the possession, knowledge, or control of the state which would tend to negate the guilt of the defendant or which would tend to affect the weight of the credibility of the evidence used against the defendant, including any inconsistent statements. The failure to disclose the audio call to trial defense was a clear-cut Brady violation. An additional Brady claim stems from the evidence from Kevin Romlo. Kevin described in his affidavit that he reported his observation of the RAV4 parked away from the Stephen Avery property to a Manitowoc Sheriff's deputy he encountered on November the 4th, 2005 at the Senex station on STH 147 in Mishicot. No law enforcement report was ever generated by this Manitowoc Sheriff's deputy. Memorializing the conversation between Kevin and this deputy about Kevin's observation of boat Teresa Halbach's vehicle, the circuit court denied Stephen Avery's motion for post-conviction relief on August 22nd, 2023. Stephen Avery filed a timely notice of appeal on August 24th, 2023, just 2 days later. On January 15th, 2024. The Court of Appeals issued a decision affirming the circuit court's denial of Stephen Avery's claims. Stephen Avery will accept the facts as stated in the Court of Appeals opinion on pages 2 to 8. Well, I'm gonna break this up because I feel like this is gonna get very long, and it'll give people a chance to just sit down and watch a part 1 or a part 2 instead of having to maybe sit through an entire 45-minute, an hour-length video. However long this ends up being, you can just watch it in different parts, or if you want to watch it all at once, you can just watch part 1, part 2, part 3, however many it ends up being. But that's the end of part 1. We're going to jump into the argument here at the beginning of part 2. I'll be right back. What do you think so far? Let me know.